So yeah, I'm Mason Baker. I'm here on behalf of the Salt Lake Climbers Alliance. We are in Salt Lake City. I am on the board, and we have a full-time executive director, Julia Geisler, who's here. We have also a handful of other folks from the SLCA. And what I'm going to talk about is largely informed by our experience as an LCO engaging in fixed anchor replacement. And hit the next slide. So I want to talk about what is the risk of an LCO engaging in this activity. And I'll do a high-level overview of potential legal claim. That's sort of what I did last time around. I'm not going to repeat that. So if people want to look at that presentation, they surely can. But it's sort of a bit dry. It's just a hypothetical legal claim. And I think it's more pertinent to talk about risk management and, as an LCO, how you go about this activity in a way that best manages your risk. And of course, one of the risks is a potential legal claim. So I'll briefly talk about that. Talk about volunteers conducting fixed anchor replacement. Talk about paying for fixed anchor replacement. That's something that SLCA has done. And then I'll be talking about mitigation strategies, waivers, best management practices, insurance coverage, and again, this is something that we've been dealing with as a board since I came on the board in 2011, and I think it's a tough nut to crack, and it's something that we keep coming back to and keep kind of changing how we're doing it. Next slide, Pat. As far as the risk goes, there's different stages where the risk exposure lies, in my mind. You've got the installation risk. You know, somebody get injured while they're actually installing the bolts. Brady referenced the recent Owens River Gorge incident. You've got post-installation risk, and that's the hypothetical lawsuit that I briefly touch on is assuming that someone gets injured by a bolt failure. Then ongoing maintenance. So once we go through the process of putting in these bolts, what obligation does the LCO have to do spot checking or whatever the case may be? So there's risk potential at all those various different stages. Next slide. But before that, I think it's important, and I don't know how many LCOs are in the room, but for the LCO to ask themselves this existential question, which is getting involved in this really part of your mission? And for us, it was something that we felt like it was, in fact, part of our mission. The reason that we thought that was because we went through a member survey and we asked them a bunch of different things. This was one of them. Is this something you want us to get involved with? And they said yes. And so we took that message, and we have been involved in it, and we use it as a development tool, and we identify the fact that we're doing it as part of our development efforts. But you could also take an alternative approach, and this is something, and I don't know if anyone's here from SUCA this time around, but back in 2012. So SUCA is a bolting group out of Red River Gorge, and what they did was they set up their own little separate type entity, and I don't know if it's legally set up like an actual LLC or anything like that, but they wanted to sort of be apart from the Red River Gorge Climbing Coalition, and that's a different approach that someone could take, but for us that just wasn't what we wanted to do, because we wanted to take advantage of the fundraising benefits of engaging in this effort. We spent hours hearing board meetings debating on whether we were going to do it. If we were going to do it, would we only do it if we got insurance first? I mean, it was...
Which there's kind of no such thing for. Like, we didn't find any insurance.
Yeah.
Is that what you all kind of concluded?
That's what we concluded, and we went through a reasonable amount of due diligence trying to see about getting insurance back in 2012, and I'll get to that in a little bit.
Okay.
I think there's maybe more opportunity for that now, and I've got some ideas, and I frankly have a much through work, I've got a much better insurance broker, and I sort of called in a favor, and this guy's really able to articulate the risk well, and I'll get to that in a minute. But
Okay.
Well, just a quick question. So with the river reward example, the key factor there was that they actually owned the climbing area. And that probably played into their decision about having it separated.
No, actually, it's because the coalition, the LCO there, it's part of their mission is that they do not have any policy about holes. And since the early 80s when all the old ones were going in, they started seeing deterioration. So we actually created Team Suck. That's what he's talking about, it's Team Suck Line. And there's basically just a group of about 8 of us that tool around with drills and fix stuff. People bought us, gave us money for beer or bolts, just to fix stuff. So it was totally not part of the LCO, but we kind of was working more or less with the LCO because people would call them or write an email to the coalition saying this anchor is really crap, and they basically just kind of forward the email.
And I guess my question there was, or point was that LCO that owns climbing areas are very different than LCO that does not own or manage.
Yeah, well, this part was for both too, yes.
Yeah, that's a good point too. As far as the legal liability, I mean, it's not a zero risk proposition to engage in this activities. I think everyone can acknowledge that. That being said, I mean, it's one of those things where you evaluate the risk and you say, well, is it worth taking? And you look out there and see what the examples are to understand what your risk exposure is. To my knowledge, I have not run across any claims or court cases where an LCO has been sued for this sort of risk, and you might say, well, why should we be concerned about that, given that there's no case law out there? It seems like the risk might be de minimis. You sort of think you got informed climbers, they just assume the risk inherent with the activity and they won't bring a claim. I think the problem with that sort of thinking, and it's this whistling past the graveyard mentality, and I don't know if people are familiar with that term. It's a term my boss uses, and I try to keep these phrases alive that I think are dying off. But I think as LCOs, and Brady was mentioning, we're growing. I mean, since I've been on the SLCA, our budget went from 20 to close to 100K. We're going to keep growing, and I think we have a responsibility to run our organizations more like sophisticated businesses, and understanding our risk exposure is just part and parcel of doing that. So as a goal, I think LCOs, and this is just me speaking, I guess on behalf of the LCO, the SLCA, we have a goal to minimize our risk exposure to the extent practical, caused by engaging in fixed anchor replacement. And that's kind of what I want to focus on, is how you can best mitigate that risk to the extent that it's cost effective. Yep.
One of the things I think you have to distinguish between is the risk for the organization and the risk for individuals. LCOs tend to be fairly thinly capitalized, don't have a lot of assets, they're not an attractive target.
Exactly.
And a claim against an LCO doesn't pass through to any of the individuals if it's been carrying on the basics of maintaining corporate practice, and so using source of bail is less likely.
And just to clarify, are you saying passing on the liability maybe from a board that's governing the LCO that gets sued, hypothetically?
Right.
Yeah.
Let's say you're a board member of the LCO. You as an individual are not liable other than for things that you have done. If the organization is sued, it's the organization that's at risk. So the difficulty, I think, is figuring out the different levels of risk for the organization, which typically isn't a great target, for individuals who are involved in decision and policy making, and for individuals who are actually doing the work, potentially installing a bolt where somebody
that's a really good point. The general proposition that a board member wouldn't be held liable, I think is absolutely true, and a lot of states have within their nonprofit statute schemes, they acknowledge that that risk shield is provided to officers and board members.
But speak a little bit to, there's a difference between being liable and being sued.
Exactly. And, I think when you talk about being minimally capitalized as an LCO, even more so, there are minimal resources. And to get sued is something as an in-house attorney, I'm not a litigator, the last thing I want to do is have my organization get sued, because it is a huge time suck, and you want to try to avoid it. And I think if I could have one takeaway from this presentation, is doing best management practices in such a way that you minimize the risk by having a quality work product, so you don't hopefully get sued because you don't have a failure of the bold. So
Just a quick question. Does a 501c3 status give you a lot more protection than kind of a more loose nonprofit organization?
Or even backing up a little more, does it matter how it's organized, whether it's an LLC, does any of that?
well, it's going to depend state by state, but in Utah there are statutory provisions that do provide more protection for board liability. But I think just generally you're going to have a plaintiff's attorney be less successful bringing a claim against a nonprofit organization versus a commercial organization. There is case law out there against commercial guide outfits. So you see that. It's a very different risk and a different risk standard that applies, because the standard of care associated with a guide conducting those activities is much higher than a volunteer going out and replacing these anchors. And I think a court is not going to be in favor of imposing liability to an LCO that's engaging in this activity, because inherently we should be reducing the risk exposure, not increasing it. So I think that's my sort of general take on it.
There's some kind of vague areas where I'm on board for Illinois Canyon. The work I do is as a volunteer, not the board's official actions. So I replace a lot of bolts, but the board I'm on, ACE, is not officially replacing that bolt. I just happen to be on the board, and I'm also the guy that's volunteered to do the work. They pay for the hardware, and so I go out and do it as a volunteer. But I'm also a commercial guide, and I'm a board member, and I'm a volunteer. So I'm like all of those things in one person, and my liability is unknown. I mean, I definitely can get sued, but I'm not doing any of that work as a commercial guide. I have to do one, and I work in the same area occasionally. So yeah, I may be a big target. I don't know.
Yeah, I mean,
Yeah.
I'm going to pass on that one. Next slide, Ty. Sorry. Yeah, I started thinking about your insurance policy. Go there. So I've kind of generally touched on this, but just to go through it in a little more detail. So the hypothetical claim generally would be that a climber gets injured through a bolt failure, and the LCO has been the one installing the bolts. And the claim is that the LCO negligently installed that bolt, causing the injury. And as I mentioned, there is this general standard of care that is owed, a reasonable standard of care. And if you deviate from that standard of care, there may be liability exposure if you're careless in how you went about installing that bolt. And it's very fact-specific, of course. I mean, did the volunteer go through the right process in installing the bolt? Did they do it appropriately? I mean, were they, I think it's great that we're having this conference. I think, we have to go about this as LCOs in a much more rigorous fashion than what happened, 20 years ago. And that's where the best management practices come into play. And I think there's a lot of value in adhering to them. So there's a couple of questions.
So I have a question. I'll be presenting later a little bit about organizing big group revolting events. And part of that is that we train people, right? So the assumption a little bit is that the LCO is doing it. They're experts in the area that are replacing the bolts. But we want to grow that knowledge and those people that are able to replace bolts. So we do training. We do training both like on the ground in a boulder, and we do training on the wall. In your opinion, does that increase our potential risk and liability of saying, I don't know. I mean, I don't know how we define who is an expert and who isn't.
Yeah.
And how would you defend that in a case?
Well, that's a great question, and it's on one of my later slides. Because, and I can just give you the quick answer, is that the SLCA, in its replacement effort, adopted this kind of mentor program, because we wanted to feel comfortable that people knew what they were doing, because it's very much, there's obviously no formal certification process that's out there or anything like that, but I think there is that duty of care to understand that the volunteers that are engaging in the activity know what they're doing. It's the same sort of things when we have trail day works. There's certain things that get ingrained into the volunteers about how they're handling the tools. This is just next level up. You're going to have to take more time with the volunteers and get them to that level. So I do think there's a lot of value in having that sort of mentor type program, and I do think it reduces the exposure ultimately. And that, to me, that's part and parcel of best management practice.
Does the SLCA have to get a permit that is specific to anchor replacement?
We have never gotten a permit for anchor replacement.
So there's nothing from the agency or anything that is dictating how and what type of fasteners you're supposed to be using?
No. So Kenny, do you guys get permits at the new?
Yeah, we
do.
have a permit that actually spells out what the minimum standard you can use. So
Yeah.
it seems to me when you start talking liability, all of a sudden, as long as we're adhering to that minimum standard that the Park Service is fine, then there's another barrier of you're insulated from someone.
Yeah.
And there's also no person is ever associated with a specific bolt.
Yeah.
We lobbied for that to not be included in any database.
Yeah, but
That's my question, is for organizations that have a cost share program, does your liability change? Do you have an agreement with land managers?
I think having not seen that cost share agreement, I don't know what it looks like. I don't know if there's indemnification provisions or things like that that are going on. I think it just boils down to the details of, generally I'd say, yeah, your liability is probably greater under those circumstances because it's something that's memorialized and can be pointed to during litigation. As far as defenses, I've kind of spoken to this a bit already, is that, this is obviously climbing is an inherently dangerous activity, so there is an assumption of risk, and this is the defense that a court would apply. And courts don't want to chill the participation in these inherently dangerous activities because they recognize that the public likes and chooses to engage in them. So that's sort of the policy reason why they apply this defense. And as a potential defendant, the LCO does not have a duty to eliminate that risk, but at the same time, they're not supposed to increase that risk. So that's kind of where the best management practices come into play. If you adhere to them, you shouldn't be increasing the risk. That's not to say that you get it right 100% of the time. That's not the standard. It's just that you adhere to the practice, and there might be a circumstance, even if you exercise the right standard of care, where an accident could happen. Next slide. So someone already asked me a bit about this. As far as volunteers conducting the work, that is the big issue. Are they skilled? As an LCO, what are sort of the standards? Even if it's not rigid standards, how are you going about the process of making sure that these guys know what they're doing? and this is something we've done, and I think it's been pretty successful as far as getting new people out there and getting other people engaged in it.
I have one quick question about when you're replacing bolts, how do you document that, whether internally or on a website like Mountain Project? Do you say that your organization did it? Do you have any records of the individual who did it? I mean, have you taken a conscious stance one way or the other?
I might have to defer that one a little bit because at one point I was taking or suggesting an approach where it be very well documented because my concern was about ongoing maintenance to understand, where they had happened, where the replacements had happened, how long they've been in there, and then part of that documentation would be to do follow-up batch testing, sort of, like where you would go and not survey all the bolts, but survey some of them to see how they were doing. And again, that was sort of a very heavy-handed best management approach. And I'm not sure if that approach is a reasonable one to take on as an LCO, given just bandwidth, people's ability to do that. What exactly has been our documentation approach?
Who was involved working on a given route, documenting what the materials were, say glue, bolts, dates, notes on where we replaced bolts and maybe where we didn't because somebody else had already come in and replaced it maybe 5 years prior, trying to do everything stainless. That's kind of the guidance that we employ as far as a given route. We're going to be working on it and try to leave the whole route as all stainless.
So does that open it up to individual liability then? And if there's the discovery, right? Like, so
Yeah.
your organization did it, then you can go down to the level and say, I am the actual person who did the work, and then opens you up individually.
Yeah, I mean, there's obviously that individual liability that could arise, and I think as the LCO, we would probably be wanting to get in front of it. And, that's sort of in the hypothetical legal claim, in the analysis that I did on it, we would want to get in there and defend that individual and sort of be the shield in front of them because, ultimately, they're doing it for the betterment, in our case, of the organization. So we want to stand behind them, and of course, if there was, it's just, it gets complicated at that point. It really does.
So I run a fixed gear initiative now in regular Gorge. We're purchasing bolts for developers to buy at a subsidized price, and we're covering all of rebolting. So a couple of questions where I have concern is with documenting for liability again at the individual level, saying that Blake went out and bolted this route on this date. Is that something that's going to come out in the discovery process anyways, regardless, and that by me saying it formally, probably no bearing on it because they're going to get me in that position and say, well, who did it? And I say, well, Blake did it. I can't lie. Right?
Yeah.
So they're probably going regardless. Is that correct?
Yeah.
So by putting on my Facebook site that thanks Blake, you bolted this, it's not going to put us at more risk. Is that correct? Most likely.
I think that's a fair assessment.
Because I can't imagine that would be hidden. I can't imagine we can stay anonymous with who's bolting a route when we get to that, if it gets to that point anyways.
Yeah.
And then my second question is, I've been really hesitant to go with any type of mentorship, formal mentorship program or anything LCO for liability, because then we're saying we have the experts, we're saying the standard, and then they can come back to us and saying that we're not training them properly or I'm worried about that. So it's been trying to fly more under the radar and more of just like, well, Joe's taking them off and doing it on my own time.
Well, and I get that concern. I think the problem is, if whether or not you have enough resources to do the amount of rebolting that you want to get done.
Well, we never do, but that's my point. Is I'm weighing, both sides.
Sure.
My trying to mitigate risk and liability, and then still get the job done.
Sure.
And so I would love to do more formal training, but my concern is that am I putting myself and the organization at more risk by doing that?
Well, it really depends on how you conduct the training. If it's done properly, it shouldn't be.
But there's no recognized expert to say that,
Yeah. Well, and that's to a certain
doing it correctly. It's just experienced by people who've been doing it for a long time.
Yeah. And I mean, it's obviously experience-based because, you know, there's no set standards exactly on how to do the training. And a lot of the wherewithal only comes through, you know, throwing in a lot of steel over the years.
Yeah,
And
so maybe the access one could come through and do a bolting clinic.
Yeah.
You know, kind of our people go through that, and we can say they've been trained to the best practices.
Wouldn't everybody else at risk though for liability?
Well, I'm certainly putting the access fund in a little more case.
Right, that's what's
So Brady said he's good with that.
Guys,
Yeah.
ask a question, and hopefully this is sort of on topic. So, I drive a car in Boulder, and the pedestrians are really stupid there. And I'm worried about running my car into a pedestrian and getting sued. And so it seems like I got two options. One is I can stop driving, or two, I cannot hit pedestrians. And so, correct me if I'm wrong, I mean, the situation we're really concerned about is putting a bolt in and having it fail and having somebody sue us. And so if we put the bolt in and it doesn't fail, nobody can sue us.
Exactly.
Is that true?
Well,
Or why would it, I mean, what I'm trying to get at here is that we deal with risk all the time. And because it's a vertical, it is different though, like you put something in, it's going to stay there for time immemorial maybe. But I guess what I'm trying to say is if I want to rebolt the roof and I put in 1/2-inch stainless, you know, anchors that are clearly, you know, strong as the rope, then what is the risk? And why is this a perception thing? Or is there actually a lot more liability that we're taking on here as opposed to driving a car in Boulder while the pedestrians act like idiots?
yeah, well, and that was kind of to my earlier point on, you know, is this risk a real risk or is it a de minimis risk? And, you know, as you were saying, the best way not to get in a lawsuit with the pedestrian in Boulder is to not hit them. And my point on that is the best way to get in a lawsuit as an LCO engaging in this activity is to make sure that the work gets done as properly as possible so you don't have a bolt failure. So I think that's maybe, as I mentioned before, the most cost-effective mitigation strategy is adhering to best management practices where you make sure that you've got a quality work product out there and you don't have a failure. Does that get to your point, Brady? Yeah. Okay.
So Mason, I put up a really popular sport ride in Boulder, in the Denver area, and this guy fell off from the top anchors and died right in front of his kids and his grandkids. And Jeffco did a huge investigation, and we were all involved, and they, you know, the family was cool with it. You know, we had Lucy hooks up there, all the bolts were stainless, you know, so, you know, they were like, you made an error somehow, but they, you know.
Yeah, and this, I mean, accidents are going to happen. It's an inherently dangerous activity, and, you know, there may not be a lawsuit in that case. You know, again, it's, you know, I was asked to speak about, you know, what the risk is and what the risk exposure is, and, you know, I mean, I couldn't imagine, you know, my family bringing a claim because of, they would know that it just wouldn't have a very positive impact and probably wasn't valid in the first instance. Not to say you can't get sued, you know. So, sorry, I think you've had your hand up for.
Is there a legitimate reason to document the who? I mean, we document the why, when, and how, and with what, but do we need to document who did the maintenance, the repairs, things like that?
Well, I mean, I think it's helpful to know, you know, if there's something that, you know, I mean, if you think about it just from a compliance, best management practice standpoint, if there's something that a particular installer is doing that's just like a little off, you know, that could be good knowledge to carry forward. I mean, that's just one thing that I could think of. And, you know, the SUG guys were bringing up the fact that, yeah, it's going to come up, that the individual's identity will be revealed if a lawsuit is lobbied. So,
I run badbolts.com, and it's a free resource for mainly for crowdsourcing when bolts need to be replaced. You know, but a couple of LCOs, mainly in Texas, they tend not to utilize who replaced it. but the install date, what was used, and that gets all the metrics that you're talking about, the seeing like where, how long the individual, put the metrics on how long they need to be replaced. But then again, the whole idea of it was to keep metrics of who, when, all of that. And then of course there's hidden ones, but in litigation it would come out. But that's typically public knowledge from, at least from the local standpoint anyway. People know who are bolting, more or less.
So Mason, let me give you an example of best practices. So we had a problem with 3/8-inch bolts, the 5 pieces stainless. They were spinning in the pinnacles because of the cone deformation problem. And we decided to try 10mm bits rather than 3/8-inch bits, because they're a little bit bigger. I engaged an engineering professor from San Jose State University. We went and did testing, drilled 10mm holes, installed the bolts, did pull testing, and now we're using the 10mm bits instead of 3/8 bits, because then the bolts are going in and not spinning. So we try to use all the resources available to us to make a change in our practices, and not just stick our finger in the
Yeah, I mean, that's sort of, I don't know if people heard that in the background, but, or in the back there, but I mean, what you're saying is that, they were having spinners and then they use a slightly different bit size and reduce the likelihood of that. And that's exactly a best management type practices that a court would look at and say, these guys, they're not just out there high rebolting, but they're really thinking about this. I mean, that's just.
I got a question about the bad bolts. Like a friend of mine who's been in climbing for ages said he'd never heard of a bolt failure except for the old button heads or quarter inchers and stuff. Does anybody know, have there been a lot of, or more than one bolt failures of the newer bolts?
Yeah,
Yeah,
I bet we probably have a bunch of people that could.
Yeah, there's the classic case from Pinnacles National Monument where a 3/8-inch 5-piece slowly unscrewed was only held in by a couple threads and someone fell.
But it was still in.
Yeah, it's still in the rock. It fell and it pulled the bolt and it broke the back. And that was late 80s, early 90s? Or
late 90s.
Late 90s?
Yeah.
Yeah.
But the other thing is hangers. So it's just not the bolt. So a lot of the older bolts, I got a whole stack over there, had defective hangers. So the bolt is actually
good, but the hanger.
But the hanger goes. Yeah.
One of the things that we're doing instead of doing the best practices, that we're just deferring that now to the access fund, and the access fund best practices. So they've got the videos, they've got all of that information, and what that does is that relieve you of liability.
It was much better than what we were able to put together.
Yeah, and there's just way well more,
Well, you can also enter into, like what we did here locally, of course, as I'm sure some of you have done, is we entered into memorandums of understanding with the Bureau of Land Management as to what was acceptable replacement hardware. So there was an agreement in place between the land managers and us, what was standard, as long as we met that, I gotta believe that would provide some security.
Your point about sort of referring to the AF's best practices, I think that's a really good idea because no matter what, when you're doing best practices, it's sort of they're general in the sense that, they're not super site specific. And there's always going to be decisions that are made in the field where you're taking account of certain, whatever the conditions are. And I think that's a better way to go because you're referring to the national standard and you're not putting yourself in a position to where you're limiting your abilities in the field because there might be some weird one-off situation and you've got to deviate from what your board approved, and I would probably steer away from that. And that's kind of where I was aware of that, kind of where we were landing. So Jason,
to the extent that you want to document the person that's doing it, wouldn't you want them to sign off somehow that they understand what the best practices are? So in other words, it would be more than just having your board approve it. Whoever it is that's going out there to do route whatever, they acknowledge, maybe not route by route, but ahead of time before they're authorized by the LCO, that they understand this.
Yeah,
that would
exactly.
help you defend that person in court once the discovery comes.
Yeah, because I mean, just as do a lot of compliance work, just as a general principle. I mean, policies are great, but you got to actually read them and adhere to them. So I totally agree with what Jason said.
So the mentor program, you kind of do, would probably be like a similar best practices that everybody's agreeing on to kind of protect yourself, sending folks out there who you feel qualified.
Yeah, I mean, I think that as part of the mentor program, you would have the mentees reading the AF's document, sort of the desktop portion of the mentor program, probably before you get out there in the field.
The way the permit system works for replacing bolts in Eldo is interesting in that the action committee is the LCO, but they have no authority. They're just an advisory board to the park. The park gives like-for-like permits directly to the volunteer doing the work, so that the LCO is not taking any responsibility for the action. They're providing the hardware for free, but they're not the ones doing the replacing, even though it happens to be the same person that's on the board acting as volunteers. So the LCO, the board, ACE, was uncomfortable as a board with accepting responsibility for doing the action of replacing. And so they say, hey, we'll buy the hardware, but whoever wants to go out and replace these bolts, between them and the park. Then they're going to go, volunteers are going to go ask the park for a permit, gets done. And it's just an anonymous group of volunteers that goes out and does that work. I think it's kind of, it may not be an effective legal strategy. I'd like to hear your opinion on that. I think the board is definitely responsible for that action, and I think they're not, as a board, just because they're buying the hardware and handing it over, and somebody else goes out and gets a permit and does it. Is the board part of that because they bought the hardware?
Yeah, I mean, to me that falls in the whistling past the gate.
Exactly.
Okay. So paying for fixed anchor replacement. This is a tricky one, and I think we're going to probably, my recommendation is that we shift away from doing this as an LCO. I know of people doing it, the VRG, not too far away from here, got totally rebolted a couple years ago. It's amazing now. But, and someone, brought from Vegas paid for that to happen. And it's great, super quality product. And that's part of the reason why I was thinking it was a good idea, is because, I saw that happen and it got done really well. I felt very confident in how it was done. And I thought, well, it's a better work product. So, maybe you're minimizing your liability by having a better work product by paying for it. The problem with that as an LCO is that there's so much that then you get entangled with. There's some weird workers' comp stuff that comes into consideration where if you're doing it right, the person installing the equipment should be carrying their own insurance coverage. And if you haven't been certifying that that's the case, then you're exposing yourself to state liability associated with worker comp type issues. So that, that's kind of something that I think we're kind of wrestling with and coming to terms with is, gee, it seemed like maybe a good idea from the perspective of getting a good installation of these bolts, but maybe the reality is that it's not workable for us as an organization.
If you're paying someone to bolt, do you need like a special use permit because you're basically paying someone to do work on federal lands?
That's a good question. I'm not. That's probably right.
I got also being paid to rebolt stuff in Red Rock, but I've beat all my firefighting. So it's like I'm the guy, it's like I got a permit to be out there making money. So how does that apply if someone's offering something to revolt?
That's just another complication. That's why I just don't.
Bottom line there, less administrative headache, right?
I think, and just another quick point on this, and we'll keep going, is that I just think from the hypothetical lawsuit standpoint, it's as soon as you start exchanging money, people are more prone to impose liability. You know, it's like, you are getting money for it, I should be holding you to a higher standard of care.
But how's that any different from being an outfitter? Like on public land?
Yeah, I mean,
And if you want a better product from somebody, you know, guiding you, you want somebody who's qualified, that they're getting paid for it instead of a volunteer.
but yeah, I mean, I think outfitters are exposed to more liability and probably ought to be. You know, I mean, that's why people hire guides, is because they want to feel safer and so I think, I mean, there's good policy reasons why it probably should be the case. Is that getting?
Yeah, well, it sounded like you're doing cost benefit, and you were saying, well, at the end of the day, it's better to just have less administrative headache. Then this product that you're saying is, you're convinced is much better.
Well, I don't know if I am. Well, I mean, it's tricky. It's like, you know, I don't think you know, the individual who did the ERG, it's not like he changed his protocol just by all of a sudden he started getting paid. I mean, I think he's always been a good bolter, always enjoyed his routes. He just had the ability to go out and do it and knock it out. I mean, that was the thing, like, that whole cliff got rebolted in like a couple months. And that's sort of, it goes back to a resource constraint issue. It's like that guy could just knock it out and we're done with that area and move on.
Some of these issues, like the workers' comp, it doesn't matter if you're paid or not paid. If you're a volunteer,
yeah,
you have workers' comp issues, whether you're exchanging money or not.
Well, that's
in some places.
It's state by state.
Yeah, state by state.
Yeah, and I'm trying to get my arms around. There's some recent legislation in Utah about this issue, and the LDS Church came out really staunchly against it because they have huge volunteer efforts. So I mean, that's just another consideration that just regardless of pain or not, that we should all be cognizant of.
One comment. I hear this word a lot like here today. It's safer or safe. And as a fixed anchor LCO, that's one word I try to never ever use in my vocabulary. Anytime I'm advocating for getting more bolts or anything we do, we do it for sustainability. Because stainless steel bolts are more sustainable, they'll last longer, better return on investment, take care of the rock better, but we're never doing it to make things safer.
Sure.
And of course, that's a side benefit because we're putting more rusty bolts, and we all know what's really happening. But that's not part of my pitch ever for why we're doing it.
You know, and I think that's a good point. I mean, if I'm hearing you right, you're saying that you just don't want to be implying that somehow you're eliminating the risk associated with the activity. Yeah, and that's safer. I think it's important for that to always be acknowledged that yes, this is an inherently risky activity. We are not eliminating the risk. Julia.
Just real quick, this might be great. To go back to that, people, volunteers, or paid people like understand, read, and adhere to the best practices to the access fund. It's a good idea to do an online form through the access fund and review all the LCOs.
Like a form that says they acknowledge the risk, or that they...
They've read the best practices.
Well, we've done this through our legal team. And then the question is, well, we're teaching on a bolt. Can we is this exposing us? And the answer is maybe, but you can learn how to drive on YouTube too. If you want, you can find driving lessons on YouTube. And then if you get in the car and run over somebody, again, one of those pedestrians in Boulder, it's going to be hard for you to sue the person who posted how to drive on YouTube. And so that's kind of the analogy that we went through. So we've taken, and again, I'm not an attorney, so I'm probably speaking in layperson's terms, but we took a kind of put the information out there approach. There's some nice language that, hopefully everybody read, talking about, all the dangers associated with it. But at this point, the Access Fund doesn't want to get into the business of determining who and who is not certified, properly educated, qualified to do X. That is a huge leap from trying to get the information information out in a way that is accessible to everybody in a kind of beautiful and easy way to understand. That was our first step. Now we're taking little baby steps, honestly, in this. As I mentioned at the beginning, like this used to be the third rail in climbing politics. And we launched this conference 4 years ago and nothing terrible happened. In fact, really good things happened. So to do it again, and we released these videos. So we're kind of on our own path in terms of what we might do. So we're doing funding, we're doing best practices over videos. And we have assets. We got like around $2 million in assets in books right now. And there's a lot of other programs at the Access Fund that we want to protect. If we got an a huge lawsuit, it would affect our ability to do the public policy, to buy climbing areas, to do all these other things. And so we have to balance our kind of risk profile with all the other things we're doing with the organization. I think the one thing that's really important to mention here is that attorneys don't give you the right and the wrong answer. No offense. They paint a picture of your risk profile, and then you have to make business and mission-related decisions based on that. And if doing the right thing, in your view, for your organization, for yourself personally, puts you at a greater risk, that is a decision you have to make. The safest thing is to not do this. The safest thing is to never get in your car, but we're all going to do those things. And so I think what Mason's doing a great job here is painting a picture of the risks and also saying what made sense to him in the case of the public consequence. But, you know, your situation may be different. I think it's important to understand that this is only one part of the equation, and it's fulfilling our mission and making sure that the bolts and anchors that we ourselves and the community folks are in good, working, maybe not safe order, and are sustainable, is the thing that we're all about here. So,
So mitigating liability, I mean, you know, obvious ways to have volunteers sign waivers just like they would sign for trail work. And I think this is kind of just an easy one. So as I mentioned, we've been talking about best practices. You know, these are general standards that could be looked to, and individuals doing the bolting would be making site-specific decisions consistent with those general standards. This is kind of the overarching principle. And the pros of adhering to best management practices, you know, you potentially avoid careless errors. And I think one of the other pros is, you know, if we're able to find insurance coverage, it's going to be based on in finding cost-effective insurance coverage. It's going to be based on being able to communicate to insurance underwriters the nature of this risk, and having best management practices is really going to go a long way in getting the underwriting community comfortable with insuring the risk. As far as cons, it does create a standard of care, so you know, if you're out there and you just blow it and do something that's clearly erroneous from the best management practices, you know, the AF's practices say to do something and you just totally deviate, then that deviation would be pointed to you as something in potential litigation. And as we already talked about, we tried to come up with our own, and it was just, I mean, that was a black hole. So I was really pleased when the AF came out with theirs.
Yeah, thank you guys. That was a lifesaver for us.
Thank you, Jason Haas.
That saved us months of work, for sure.
Yeah. All right, so insurance. You know, as I mentioned, this was something that, as a board, before we started engaging in this activity, I was asked to, and Julia and I went and talked to insurance brokers, and we got a quote, and it was sort of like suspect. They were like, oh, like this seems sketchy, and it was, I can't remember the exact number, but I think it was around $13,000 a year, and for an LCO, I don't think that's really that manageable. Out of the LCOs in the room, does everyone have insurance, like general liability coverage?
No.
Does anybody not?
Okay, well, something to maybe consider. Because general liability coverage is not really that expensive on an annual basis. Julia, you just renewed ours. How much is it? It's like, I think last year, I was looking at the premium last night. It was $1,300 bucks.
Yeah, it wasn't about $3,000.
Okay. Probably just out of prudency for an LCO, it might be something to look into.
And how is that for events and stuff?
Yeah, for fundraising events. And,
Maybe to add on, like volunteer accident insurance, which is basically workers' comp and commercial volunteers, it's another $400.
Yep, exactly.
And directors and officers.
And that.
And D&O, yeah.
$2,500 your leg.
Yep. So we freshened up this quote. As I mentioned, I've got a new insurance broker, and I called in a favor, and he's helping me out on this. And so this was, as of yesterday, they were coming in at 7K. As of this morning, it's at 6K, and it's partly because we're keeping the dialogue going with the underwriters, and they're getting a better handle on the risk. And I think that can keep going down. And for a lot of organizations, even at 6K, that's probably out of what's realistic as far as what you could obtain on an annual premium basis. And I don't know, even for us, I don't think that that's something that we necessarily want to bite off. That being said, we've been talking about potential for sort of a more nationwide programmatic type policy, and the underwriting community seems a little more psyched on that because it'd be a higher premium, and that's something that I want to keep exploring with them. Just because doing like a one-off deal with one LCO where they're getting 5K in premium a year or whatever, this doesn't do it for them. So that's something that I'd like to explore, and having the best management practices that the AF has in place is certainly, I think, helpful in having those conversations with the underwriting community. I just want to keep that conversation going and seeing if it might not work out, but I think it's worth exploring. And before I take these questions, the one thing I was finding was that the marketplace that's probably going to place this risk isn't like the Guide Insurance or Ropes Access community. It's a little different. There seems to be more appetite within kind of like construction risk on this. So more similar. Yeah.
I mean, I understand that we're trying to be proactive, right? But it seems like if there's no precedent, if there's no LCO that's actually ever been found responsible, I mean, I don't know, does it make sense to, protect against an issue potentially, that isn't really there?
I can speak to that.
Yeah, I mean, yeah,
So
go for it.
It's getting your board of directors to buy in. If there was affordable insurance that groups could buy into, it makes it so much easier to get your board of directors to say, okay, we'll do this. And I think it will unlock this key for a lot of smaller LCOs that don't have the resources that SLCA does, don't have legal counsel. If this was available, it just then we don't have to have some of these other conversations. What is going to happen in the house? So I'd like to find out real quick, if the SLCA was able to find a broker who's an underwriter who's willing to look at this, how many LCOs think that they might be interested in purchasing a policy for road replacement? I know ours would. Yeah, well, that's the question, but so it's coming down, and the more people, this is the problem, is an underwriter doesn't want to insure one dude or one group. They want to insure they need a big pool. So if there's no pool, there is, I think, correct me if I'm wrong, the price would probably start to come down. If there's a bigger group, so would that help? If there was if you had 20 other LCOs all saying yeah.
I can speak to that a little bit from a practical point of view. The point about additional insured is interesting because typically the primary insurance premium is pretty steep. That's the 10K or 7K. Additional insured endorsements tend to be very cheap after you've got the initial policy. So that would be the big benefit of having
so we have insurance policy to manage the claims. It's trouble line. It covers, the umbrella group is really the land trust community. So your policies are cheap, $1,000. It covers stewardship events, it covers land you own and allow free co taxes on, and it's based on each state record use statute. But my biggest challenge is it's pretty silent on anything like fixed anchor replacement. So the easiest solution would be to figure out if that would be included in that policy, because that's a pretty affordable option to go. But it's tailored more towards LCOs that own land, hold management agreements, hold easements. So that would be another question, is do you need to go somewhere else and have a separate policy, or can you build it into a really affordable policy like that? So I'm definitely interested in trying to figure it out.
Just to amplify on Joe's point there, sorry, what's your name? Javier's point. I think if we're able to have the conversation with the underwriting community to where the premium becomes cost effective for us, I think it's viable and could be really beneficial, even though, like you say, there's not a ton of precedent out there. It's just like for any business setting, if you can minimize your exposure by paying some minimal fee on an annual basis, it just seems prudent to do it. So I think it is worth exploring. Maybe at the end of the day, it's something that's not cost effective. But I guess I've been optimistic based on having a better dialogue on explaining the risk, because I don't think the exposure is maybe as bad as some of these underwriters are initially looking at it and being like, oh, these guys are, it's not just like people out there willy-nilly throwing in steel. It's not what we're doing. And adhering to the best management practices really helps in that.
I'm curious how the ASCA has dealt with this. Obviously, you guys have replaced a ton of them.
Yeah, well, early on, Chris consulted a bunch of lawyers, or several climbing lawyers, and they said the number one protection the ASCA has is no money. So we've talked to the climbing lawyers, and basically we're not particularly worried about it. I think the bigger risk I would be worried about, I don't think, climbing bolts just tend not to fail, especially mock bolts. I think the bigger risk just from having to replace a ton of bolts is a rebolter is out replacing bolts, their fixed rope knocks off a block and kills somebody, or something like that. Or, there's a bunch of people out replacing bolts and somebody actually gets hurt or killed, and their family sees you. Because that would seem to be a higher risk as far as I'm concerned. But insurance has never been something that we could possibly afford, since we supply bolts to hundreds, if not thousands of people across the entire U.S. and Thailand and Mexico. It's like, whatever the insurance premium is, it's higher than our entire annual budget. So we basically don't worry about it. And one of our 3 board members is a lawyer, so I don't think he's too worried about it. So but our basic, we're small and we're not too worried about it.
Okay. Yeah, I guess just to wrap up, again, I think the goal that we have as an LCO is to minimize our risk exposure to the extent practicable, and the ways that we're seeking doing that is adhering to best management practices, and that's the most cost-effective way to do it. At this point, I don't think we've found any sort of insurance product that's going to provide us with further risk mitigation, but we'll keep looking at doing that. Doing the mentoring program, I think has been helpful for us, get more people out there doing the work. And one thing, of course, I mentioned getting the volunteers to sign waivers, but also just to look at your existing insurance policies. And it sounds like a bunch of LCOs don't have those, so that might be worth exploring as well. Just in the category of risk mitigation. Yep.
Where did SLCA get their waiver, and would you be willing to share with other LCOs?
Sure, yeah.
Because for our stewardship days, we use the excess funds waiver and the forest service waiver to cover us all. We don't really have one for replacement.
Yeah, I'd imagine Mike Beck probably originally drafted it and then I tweaked it. I don't know.
Mason, is it worth talking about personal liability, like an umbrella policy just for us, I mean, I carry something like that, and that's pretty cheap, it's like $100 per $1 million.
Yeah. I was just talking about for an organization.
Yeah, but I mean, just in case, I mean, just as a